Since we finished packet 1, which includes all the forms that you need to file your actual divorce action, this packet is for people that have no property or no children or no minor children. And what no property means is no assets or liabilities that you need to divide. And no minor children means any children under the age of 18. So if you don't have any of that, this is the packet that you will use. And if you look at it, the first page has the listing of all the documents that's included in this packet. And it's basically two things, which makes it really simple. It's the petition for dissolution of marriage and with no children, no dependent or property, and the final judgment. And if you see the little asterisk, as I mentioned before, that means that that form has to be notarized before you can file it with the court. All right, so now we're going to begin with this packet. And if you scroll down or you skip pages, the first page is the actual title of the document, and then you'll have about 4 pages of instructions, which we're gonna skip because that's basically what I'm giving you some information about how to file. And again, if you forget what I mentioned, you could always go back and read the instructions, so they're always there for you. And it also gives you special notes and all the required documents that you need to file with it, so you have that information on hand in addition to what I'm going to be discussing today. So as I mentioned earlier, every document that you file with the court has to have the case style, and we mentioned the judicial circuit that and the county that you're filing, and you as a person filing it is the petitioner, and the respondent is the person that you're seeking the divorce from. And again, as I mentioned, that there is no case law at this time, case number at this time, because the clerk is the one that will be assigning the case once you file it. And the division you could leave blank, but if you wanted to, you could always write domestic relations, because that's the division that you're filing this document with. And as I mentioned, the first document here is the petition for dissolution of marriage, and that is the actual document that you're seeking the divorce from. Petition is actually paper form of requesting the court to take some action. So you're filing a petition to seek a divorce, and that's what dissolution of marriage is. And we're going to go over each section so I could explain to you what you need. First, you have to file your full legal name, which is first, middle, and last, as it would show on your Social Security card, so make sure you have that. And jurisdiction, and earlier I mentioned that the court has to have jurisdiction, and it says jurisdiction/residence, which it involves both. And at least one of you has to be a resident of the state of Florida to file a divorce action here. So if you're both, you could check both right there, where you're both a resident of the state of Florida. But if you, the petitioner, is the only person, then you could check petitioner, or you could still file a divorce action if the respondent is a resident of the state of Florida. So you have to check which one applies to you. And also, the next question asks about military service. Remember, we discussed that earlier regarding affidavit of military service. So this is just summarizing what we did there. And here they also ask whether the petitioner, you are in the military, and the respondent. So I'm assuming majority of you are not, so you would check not. But however, if you are, then you will have checked E, is. And so, and as I mentioned earlier, that you get some benefits if the respondent is a member of the military. Next, it asks about the marriage history, and this just asks you the date, month, date, and year of the marriage and the place of marriage. If you got married in the state of Florida, you could write the county and the state. However, if you got married overseas, you could write the city or of the state country that you got married and the name of the country. Also, if you're out of state and you don't exactly know which county, as long as you write the city and state, that's sufficient. And the date of marriage, you have to have the actual month and the year. If you can't remember the date, that's okay, but as long as you have the month and the year. And number 4 is saying that there are no minor children. Remember earlier we said this document is for people with no minor children or dependent children. And this is dependent children in common. What that means is minor children that were common to the person that you were married to. So if you have a minor child from a different person, then you could still use this form. And number 5 talks about the social security number form, which we went over with packet 1 and which will be filed with this document. And then number 6, this is the actually important part. You're saying this petition for dissolution of marriage should be granted because, and everyone is going to check A, which is the marriage is irretrievably broken. And unfortunately, in the state of Florida, the only reason or the main purpose of divorce is irretrievably broken. And what that means is that you just don't want to be married anymore. And Florida is a no-fault state, so regardless of what the other party did or regardless of what they're accusing you have done, as long as you say, I no longer want to be married, in the state of Florida, you could get a divorce. Or B, which is very rare, is if the person that you're trying to seek a divorce from has been adjudged what we call mentally incapacitated. And that is basically they've been determined by a court of law that they are not able to make their own decisions, and that judgment has to be filed with it. And just to let you know, majority of time B would not apply. And in the many years that I've worked, no one has ever checked B. So always A will be your primary reason. And number 7, as I mentioned, there are no marital assets or liabilities. What that means is there's nothing for you two to divide. You might have assets, you might have liabilities, but it was not during the marriage or from the marriage, so you don't want to divide it. In some instances, people will still use this if they feel like, you know what, I don't care. He could keep whatever he wants. I get to keep whatever I want. She could pay all her debts and I'll pay my debts. So that's when people will use this form because they don't want to go through the hassle of dividing any type of property. And number 8, what this involves is alimony, spousal support. So if you use this form, you're basically saying that I'm giving up any right to future alimony now or in the future. And I just have to give you a warning that if you give it up now, you could never go back and ask for it later. So that's one of the conditions that you have to file this divorce. If at this point you're like, you know what, I don't want to give up my spousal support or my alimony, I'm entitled to it, then this is not the right form for you to use. You'd have to use something else that involves property division. So just to let you know that if you're using this form, you're giving up your alimony. And number 9 is for the ladies that are seeking the divorce. If you would like to go back to your maiden name, now is the time to ask for it without seeking a separate court order. And just to let you know, if you changed your name when you got married and you at this point were like, I don't mind, I'll just keep his name. However, if you change your mind a year from now, 2 years from now, 10 years from now, and you're like, well, I should maybe change it back to my maiden name, you have to file a separate court action. So if you think that you might want to change your name back to your maiden name, you could at this time request the court to change it and always hold on to it. You could say, I might not want to change it now, or maybe in the not in the next 6 months, but maybe in the future you might want to change it back to your maiden name. Then you could use this court order to go and to get your driver's license changed, your social security number card changed, your passport changed. So it's always good to have if you want to. However, if you really don't care and you want to keep your married name, you could not check this and then keep your name. Unfortunately for the men, it doesn't apply, so just disregard it if you're a male filing. And any other relief. And this is sort of unique because this will involve any type of division or issues that may not have been addressed above. And in this type of divorce, it really might not apply because if you're seeking to divide, let's say, property, again, this form would not apply and you could not seek other relief. One other thing that sometimes people ask is if they have a pet and they have issues regarding who's going to have quote-unquote custody of this pet, then sometimes they will list it on the others. But I would say majority of the people, they have no other issues that they want to include, especially for a quick divorce like this. And in the last section is request. This just summarizes what you've asked for the court to do. And you're first asking that the divorce be granted, and if you want to change your name or anything else, you would check it. If it doesn't apply, you don't have to check either one. And as I mentioned in the beginning of this form, you have to have this form notarized. So you say you're forming, and then under it, the notary have to sign. And make sure that they sign it before you file it, otherwise they might not send it back. So that's the petition for dissolution of marriage. The next form you will see is a final judgment of dissolution of marriage. And what this is the actual form that they give you to grant the divorce. And as it states, if you look at it, it says final judgment. And a final judgment is what we call, quote unquote, the divorce decree. And in the state of Florida, they call it a final judgment of dissolution of marriage. And if you look at the top, you're going to fill out the top. And what you're going to do is leave everything else blank. And the reason why you're leaving this blank is because the court is going to be filling it out. As you see, it says ordered and adjudged that the marriage shall be dissolved. And if you look at the second page, it will show the circuit court. So you yourself, as the petitioner, does not have to do anything other than fill out the top part. And once the court signs it, what they will do, the clerk will send you a copy of the document. So now that you've filled out the petition for dissolution of marriage, the next form that you're going to do is about process server. And we'll go over that with the next video.